everyone, and thank you so much to the OECD for inviting me to participate in this roundtable. Today, I'm going to discuss acquisitions of potential competitors. I'll start with the US law, and then I'll talk about what I think would be a roadmap for the analysis, and I'll end with some thoughts on the various calls for reform. So in the United States, courts have divided acquisitions of potential competitors into two doctrines. The first is the perceived potential competition doctrine, which refers to present competitive effects based upon the threat of prospective entry. The second is the actual potential competition doctrine, which refers to future competitive effects that would likely be felt from future entry. So the first doctrine has largely fallen into disuse since the 1980s, so I'm going to focus on the second doctrine. Under the second doctrine, the government and private plaintiffs must establish three elements. The first is that the market is highly concentrated or oligopolistic. Second, that absent the acquisition, the alleged potential entrant would have entered the market in the near future from de novo entry or toehold acquisition. And third, that there's a substantial likelihood of pro-competitive effects in the future due to entry. Now, several courts, as well as the FTC, have also required a showing that the alleged potential entrant is one of only a few firms that could have entered the market. So let's talk a little bit about the standard of proof for the second element on entry. So there's conflicting court decisions in the United States. We have the FTC, at least in the past, and some courts that have applied a heightened standard requiring clear proof that the firm would have entered the market. However, there's at least one US Circuit Court, as well as the FTC in its unsuccessful 2015 challenge in Steris, that have applied a probability standard. In determining the likelihood of entry, courts have considered both objective and subjective evidence. So objective evidence refers to financial and technical incentives and abilities to enter, whereas subjective evidence refers to internal company documents and statements by executives indicating imminent plans to enter the market. In my own view, when you're considering subjective intent evidence, I think it's important to distinguish between things like comments in a business plan versus an actual capital request to build a product. So many say that, wow, these standards are difficult to meet, and they can be, but there's a good reason. So for example, as in any merger case, the analysis requires examining two counterfactuals, the future world with the acquisition and the future world without it. So of course, prediction is inherent to all merger analysis, but when you have actual competition, we have a history of competition, including actual prices, which makes the second counterfactual less speculative. This is particularly true with mature markets in which the actual and future worlds without the merger are likely to be similar or the same. But this is not the case with potential competition, which makes the second counterfactual even more speculative and difficult to determine. So now I want to talk a little bit about what I think might be a roadmap for analysis. So first, the amount of uncertainty in predicting how markets will evolve dictates a dynamic rather than a static analysis. This includes avoiding an over-reliance on market shares based on narrowly constructed markets. Second, really as within all antitrust cases, there needs to be a clear articulation of the precise theory of harm. So what's the nature of the competition that will be lost? What barrier does the acquisition raise to other startups and existing competitors? What type of innovation will be lost and not replaced? In dynamic markets, I propose that we should focus on harm to the competitive process. And this would include whether the acquisition raises the cost of entry for rivals, eliminates a competitor with identifiably distinct and irreplaceable assets, or creates hindrances to obtaining and using inputs required to effectively compete with incumbents. Now, I want to be clear what I mean by competitive process standard. What I'm referring to is the idea that antitrust laws should be focused on whether specific conduct impairs competitive conditions in a significant area of commerce and thereby harms consumers. I'm not talking about being concerned when the conduct would make life considerably more difficult for competitors. So let's talk a little bit about high-tech markets in particular. The early US potential competition cases seem particularly focused on relevant geographic market differences. So for instance, a regional firm acquires another regional firm. In other words, geographic extensions for existing products, which are a little bit more certain, right? We're talking about products that are already in the market, they've already been created, but it's just a matter of, can you create it in New York if you've already created it in California? But in high-tech markets, it's not just immediate entry that tempers behavior, but it's also the threat of the next generation of products and services that is of concern to incumbents. I want to talk a little bit about the platform ecosystem expansion theory. So a focus on the competitive process would properly orient the analysis and does not put undue weight on considerations such as platform ecosystem expansion. The fact that a firm with significant market power expands into adjacent areas of commerce through an acquisition tells us little about the impact on the competitive process. Instead, such expansions are just as likely to offer platform participants more competitive options rather than less, particularly if considerable resources are devoted to innovation. So, what are the relevant questions? Within this harm to the competitive process framework I've described, some of those questions include, does the acquisition raise identifiable barriers to entry that would impact the timeliness, likelihood, or sufficiency of entry? Did the acquired firm have assets, including patents and R&D capabilities, that are not easily replicated by others in the market? And are there competing startups, or is the potential competitor the only material startup in a differentiated product space? And if so, why? So now I want to talk a little bit about my own thoughts on the various calls for reform. And this section of the PowerPoint is based upon an article I wrote with Jimmy Moore last year, and I have the link to the article here on the slide. It has significantly more details than I'll be able to cover today, so I just want to make sure folks know the article exists. So let's talk about the existing evidence that antitrust laws are insufficient to deal with acquisitions of potential competitors. First, it's significant that the advocates of reform generally rely upon economic theory. Now, don't get me wrong, economic theory is certainly important, but it does not answer the question of whether existing standards have resulted in substantial harm to consumers so as to justify new standards. Now, there are a few advocates that point to empirical studies, namely merger retrospectives. In the article, I discussed the flaws with some of these merger retrospectives, but most importantly is that in going through all of the individual studies in these meta studies, with one or two possible exceptions, the studies don't involve acquisitions of potential competitors. So they're really not informative on the question at hand. Now, there is one empirical paper, which is the kill zone paper. And while this paper purports to demonstrate that venture capitalist funding dropped significantly following the 9 acquisition studies, the question is why, right? So the author's theoretical model offers one hypothesis. They say the threat of an acquisition dries up the innovation space and discourages ex ante innovation. But an alternative explanation is that startups enter with full knowledge and even the desire that they could be bought by an incumbent. As such, when an acquisition occurs in a certain innovative space, there's no surprise that a venture capital funding and incentives in that space goes down. So let's talk about the limitations of this kill zone paper. The authors themselves caution that, quote, it is not straightforward to go from our findings to policy. They say in our model, allowing incumbent platforms to acquire new entrants enhances ex post efficiency, but may reduce the ex ante incentives to innovate. Thus, the overall welfare implications of allowing mergers depend upon the relative importance of ex ante underinvestment vis-a-vis ex post inefficiency, end quote. So let me just end with some takeaways on the various reform proposals. Without evidence that existing standards are insufficient, or importantly, where to properly draw the line, the proposals that would like to shift burdens of proof, they risk condemning and deterring pro-competitive acquisitions and harm to competition and innovation. And these harms can include the potential to short circuit the integration of pioneering new technologies into existing products. The other thing is that many of the reform proposals would introduce new standards, and some of them are quite vague. But even if they weren't vague, brand new standards will have to be interpreted and given meaning in the courts, and that can take a very long time. So these new and vague standards create uncertainty in enforcement in the meantime, and this can serve as a tax on transactions, right? The seller is concerned about the risk of substantive concerns over foreclosure and risk that the deal may be blocked, which causes sellers to demand higher prices or larger reverse break fees to protect themselves. And with that, I will end. And again, thank you so much to the OECD, and thanks for listening to me.